People's Platform.
Good evening and welcome to the People's Platform. As we navigate an era that is defined by rapid technological advancements, safeguarding personal data has become more critical now more than ever before. Tonight's discussion will seek to explore the multifaceted dimensions of personal data protection frameworks, specifically why they matter, how they impact individuals and businesses alike, and what principles should underpin effective regulatory mechanisms. Now, after several rounds of multi-stakeholder consultations, Sri Lanka enacted a Personal Data Protection Act, the PDPA number 9 of 2022, which will be fully operationalized in March 2025. That's next year. How must we then move into a culture of data protection and data privacy, from enhancing trust between citizens and institutions to fostering innovation whilst protecting privacy rights? Now, the journey ahead will require the buy-in of the Sri Lankan citizenry. To discuss, we've invited to the studio, joining us for the first time, former chair of the drafting committee of the PDPA, attorney at law, Mr. Jayantha Fernando. Good evening and welcome.
Thank you. Thank you for having me over.
Mr. Fernando, personal data has emerged as a valuable commodity that is integral to economic prosperity. But on the flip side, the collection, use, storage of personal data can cause significant risks to individual privacy, security, and autonomy. As a precursor to the discussion tonight, could you take us through the importance of having a Personal Data Protection Act? Why must we prioritize it?
Yeah. Thank you, Sonali, for having me over this evening for the discussion. Well, the PDPA and its origins goes back to maybe perhaps 10 years of discussion about the need to have a comprehensive legal regime for a number of reasons. Firstly, the law was found to be a necessity in the context of personal data being gathered by government entities, private sector entities, banks, telcos, internet service providers, and now in the era of digitization and the social media usage, you have a number of platforms in which users from Sri Lanka can engage in a number of social activities ranging from marketing to promoting their own views to also to gather information and do business. So in that context, when individuals in Sri Lanka engage in broadly business activity, over the years it became clear that not just our individual identity but our ID card information, our telephone, our mobile, email addresses, online identification, identities would all be captured by organizations, clubs, schools to government entities across the board. And in the context of digitization, there was a necessity to protect individual rights and create an environment where users would have the trust and confidence in engaging in online digital activity. And that's one of the reasons why this law was given priority over the years. And in 2018 there was a very interesting discussion organized by a series of stakeholders through Central Bank of Sri Lanka, Ministry of Justice, Ministry of Media and Communication, and our digital ministry at that time, which identified the gaps from a number of perspectives. And ultimately it was found that not having a law would create a challenge for a country that wanted to engage in international economic development activities and international investment, And when our companies wanted to invest or promote themselves in foreign countries, a lack of a law from the country of origin, a lack of a data protection act was found to be a bit of a challenge.
Sure.
And on the other side, when we were attracting investors, tourists to many other high net worth individuals to the country, how their data, personal information as well as financial information will be protected became a thorny subject that was raised in investment forums that were carried out by Securities and Exchange Commission, Colombo Stock Exchange and others. So these combined reasons led to the authorities getting together to create a data protection drafting committee to identify a way of getting such a law drafted. That's how this whole ecosystem came about, and the necessity arose primarily from digitization as well as other development activities ranging from social registries to our governmental organizations having a large segment of personal data to provide a service which created a necessity to protect individual rights.
Thank you, Mr. Fernando. We also need to discuss the drafting stage of this bill. Sri Lankans are oftentimes used to bills being abruptly, haphazardly brought in by successive governments. So this is different in the sense that the PDPA drafting committee held a series of multi-stakeholder discussions prior to the bill being presented. Speak to us about that whole process. You were also former General Counsel of ICTA and the chair of the board of SL CERT. So you bring in a plethora of dimensions to this, which is needed in the drafting process.
Yeah, thank you. That's a very interesting point that many stakeholders are now bringing, and I'm thankful to you for that, for flagging that point. Well, you're right. Most of the laws are being drafted sometimes in closed doors. It is at the government or ministry's option to do so because of no clear regulated process defined in any rule book with regard to the process of drafting, except that there are fundamental principles of a drafting process having to be preceded by a cabinet paper that would outline the policy framework, and thereafter the legal draftsman's department would formulate the gist of it, and then there will be a review process, and then you go in for the constitutional certificate to Honorable Attorney General, where there again there will be a rigorous round of review. That's the usual approach. But in this case, we saw it appropriate, given the multiple stakeholders involved, not only in government, a large segment of private sector, and potential investors, not only in the financial sector but in the digital economy sector, potentially being benefiting from the law. And then on the other side, the civil society groups and other organizations, including the Bar Association and organizations like that, which wanted to promote and develop a framework, a comprehensive framework for privacy. All these stakeholders were interested in the subject and enthusiastic, and we felt appropriate, and I had to take a call on that earlier on, that we would have a process of what we call public consultation at various stages. So it was very fortunate at the time the then Secretary to the Ministry of Digital Infrastructure agreed with us that firstly that the drafting committee would not just be government officials. I was from government. We would have legal draftsmen's department officers seconded. officers from AG that would give reviews from time to time on the constitutionality of it.
Right.
And then we had private sector. A significant number of private sector expert professionals volunteered their time from the telcos as well as from the central bank and many other places. And I highlighted especially those from the telco sector who had significant expertise to come on board to volunteer their time. So we had a public-private collaboration, and that was helpful to bring the broad perspectives. And one of my colleagues in the team, who was also a leading counsel at that time, encouraged us to release every single version into the public domain. So we thought, I thought, why not? And the ministry agreed to it, and we documented the process. And the first framework paper was published online and distributed for public comment on the 16th of June 2019. And I still remember 27th of June 2019 we had our first stakeholder meeting, which included government, civil society and large private sector conglomerates including Ceylon Chamber of Commerce and many others coming and representing and sitting through a full day session, going through various segments of the bill or the framework of the bill, giving inputs, so people got a flavor. And thereafter the Legislative Legal Drafts Department carved out various versions, and from about August through October 2019 every single version was published online. And thereafter even with the various changes that occurred, it was very nice to see that the authorities concerned agreeing to the momentum and that open transparent model being continued. So right through that period thereafter up until 2021 November, this draft was published, put online for public comment, and the end result, Sonali, was that not only Sri Lankan stakeholders, we had a large number of international experts from international organizations, tech companies globally, Asian Internet Coalition, which comprises of Facebook to Twitter, Google and many others, to Visa, Master, Amex, a lot of them sending valuable feedback. And we had 33 written submissions, 7 rounds of stakeholder consultations, which helped to nourish the ingredients that went into the formulation of the final product.
That is fantastic. I think transparency and democratization of processes can work such magic. My next question, Mr. Fernando, now this act is different from an act like the Right to Information Act, for example, because the Right to Information Act exists. If you wish, you could use it. If you don't wish to, you can just be. But if you're a business organization or an SME, you need to be proactive, you need to bring in compliance measures, you need to equip yourself with the knowledge pertaining to the Personal Data Protection Act number 9 of 2022 in order to function as a business entity in Sri Lanka, because the operationalization of this act will commence from March next year. So you need to equip yourself with the knowledge. Tell us about this shift that is required.
Very interesting perspective that actually you brought out, that in relation to the Right to Information Act, you're right. It emanates from a constitutional right to information embodied in Article 14A that came out through the 19th Amendment to the Constitution, if I'm not mistaken. Now, in relation to data protection and privacy, there is no constitutional right to privacy whereas somewhere in Article 14A there is a provision, I believe, which says that there could be exceptions to the right to information, and one of those exceptions could be national security, criminal investigations, and the right to privacy, etc., etc. Now, if you look at that small area and look at what was done here, this is whilst safeguarding privacy of data subjects and defining how personal data should be processed, sets minimum criteria for compliance by organizations. And when we look at the global evolution of this subject, starting from, let's say, the OECD privacy guidelines to the APAC privacy framework, which was founded on the OECD guidelines, and then the European evolution, starting with the European directive, then the General Data Protection Regulations, GDPR, that also came through the OECD foundation. The pattern has been to build minimum compliances with regard to processing of personal data, with a set of minimum principles that needs to be complied with by government, private sector, and others who collect personal data, with the objective of ensuring that trust and confidence is built in the ecosystem for data subjects or individuals to engage with government entities more meaningfully, engage with private sector entities more meaningfully. So that is the shift I can see that comes in these kinds of legislation, which are more compliance driven. But I just want to qualify what I am saying by emphasizing on one important aspect, that the Personal Data Protection Act fundamentally was built with the objective of facilitating growth and innovation in the digital economy. And that is articulated in the first paragraph of the preamble of the statute. And the second principle is that the data protection regulator or the authority is required to build measures to ensure interoperability between the various enforcement regimes to strengthen cross-border cooperation amongst the enforcement entities. So that is done with the objective of ensuring that our law is harmonized and built on the best practices around globally to support innovation and growth in the digital economy, attract investors in this area, so that we can potentially be a hub in the region to facilitate personal data processing, as well as use it as a transit hub for that kind of activity. So the law is fundamentally built on a principle that it does not criminalize. In terms of sanctions, we don't have criminal penalties, but we have what we call a soft law tool for course correction, and even in the event of a further violation only we have penalties. I'll come to that later in the discussion.
Sure. Let's also discuss the importance of citizens being aware of the rights that they have when it comes to their own personal data.
Yeah. So the law, one of the reasons it's comprehensive is that whilst containing principles for processing of personal data in part 1 of the law, part 2 of the law provides for certain rights which are called data subjects rights. So you have the right to access information about yourself with a government or a private sector entity. You have the right to rectify or modify your personal records be it in the election registry or with your Grama Niladhari or with your bank or your telco or your social media entity that you deal with. Then there is also the right to erase, right? But we have to remember these individual rights, which are broadly found in Part 2, are not unilateral rights. You have to balance those rights with the rights and obligations imposed on the controller, quote unquote controllers, those entities that collect our personal data, in relation to other operative laws. So for example, if you look at the banking sector, a licensed bank has to comply with a whole host of regulatory obligations. They have to retain information for a period of 6 years or so, somewhere around that period. They cannot erase, and then they have to sometimes provide information related to suspicious transactions to the Financial Intelligence Unit under the Financial Transactions Reporting Act. Now, the law recognizes those obligations on entities that gather information imposed through other laws. And for example, if there's a criminal investigation, there is no way that an entity can erase the records.
Sure.
So those safeguards are built in.
Right.
But subject to those safeguards, individuals have a variety of rights which were not present earlier, including the right to know what the right to access their information in organizations that may be holding their records.
The Act also sees the establishment of a data protection authority. Briefly, let's talk about the importance of the role of this authority.
Yeah, so the Data Protection Authority actually was carved into the law during the committee stage amendments. In the earlier versions, the intention was to use an existing regulator and for the relevant minister to designate an existing regulatory authority as the Data Protection Authority. But the international evolution of this subject has gone in a direction, Sonali, where by definition privacy data protection related regulators are required to be independent, to function independently, and should have the ability to collaborate effectively with other regulators. And there are evolving standards in this domain, including those emanating from the Global Data Protection Assembly.
Okay.
Right? There's something called the Global Data Protection Assembly or Global Privacy Assembly, GPA, that ideally in future the regulator should be part of. But there are criteria for entry in relation to how a regulator functions, how independent they are, how well resourced they are. So the law was adjusted, the committee stage amendments were brought in during the final phase to create that model, an independent regulatory structure, and the Data Protection Authority's mandate, which you find in section 31, is quite vast. The objective of the DPA firstly is to regulate processing of personal data in accordance with this act. That's straightforward. Second one, to safeguard the privacy of data subjects from any adverse impact arising from the digitalization of procedures and services in the public sector as well as private sector. And then thirdly, to provide mechanisms to ensure protection of personal data of data subjects engaged in digital transactions and communications, and ensure regulatory compliance with the act. So you can see it intersects private sector, governmental and other organizations that may be processing personal data, and its mandate is pretty wide. But we have to be cautious because in terms of managing expectations, because the Data Protection Authority is still being set up, and the board has been appointed with its chairman, and the criteria for the chairman and the board are defined in the law. There is a couple of tests that has to be satisfied, but along with it, the building blocks are being worked out to set up the infrastructure and the resourcing, and hopefully the resourcing and structure will be ready by later this year, so that it will be able to regulate effectively and meaningfully. But we have to be mindful of the fact that this is a brand new subject, a brand new regulator, and time and space has to be given to the regulator to define the rules, regulations and the guidelines, perhaps through a public consultative process, and then move gradually in the direction of maybe giving guidelines, giving guidance to parties in relation to compliance, educating the public or the organizations about compliance measures, and supporting implementation of this act. And Sonali, on that note, I must say that the country and the regulator is taking first steps, and I would call it baby steps, in a long journey which many countries took 5, 7, 10 years to reach maturity. So we need to be a bit supportive to any brand new regulator, not to expect a lot immediately. Gradually over time they can get their act together, provided all stakeholders also support them.
Absolutely. Thank you. We are in conversation with Attorney at Law, Mr. Jayantha Fernando. We're going for a short commercial break. We'll be right back.
The People's Platform.
Culture and tradition, a celebration and an offering, all for a good cause. Sirasa Namami Pinsara Samadhiya on Asala Full Moon Poya Day, live from the Kataragama Kiriwera premises, from 6 a.m. onwards on Sirasa TV. Join us, dressed in white.
Companies play better politics than the politicians of today.
We are not supposed to play with the people's expectation. Then it will be a huge disaster.
When you're bankrupt and when you're going to bankruptcy, two different.
The grandfather is saying it is going to take this long. What does he know?
It's about the lack of sense of humor in Sri Lankans.
Issues that matter the most. Unfiltered discussions. Real answers. Face to face. Monday to Thursday at 8 p.m. on TV1.
කියන්න කොපිකන් අංකල් මං කිව්වනේ අංකල් මං අහම කියන්නම් කියලා මරණය ගැන අපිට සැකයි
පුරුවට බය කරලා වගේ තල්ලු කළා අතප්පය කළා දාන්න කියලා විතරයිනේ මාලේ ඔච්චර ලොකු ඇක්සිඩන්ට් එකක් කරන්න කියලා මං කිව්වේ නෑනේ
පූජා කියලා ලේඩි කෙනෙක් මේ හිටියා නේද ඔව් සර් ඔව් එයා මැරලා ඉන්දදී තමයි හොස්පිටල් අරන් ගිහලා තියෙන්නේ මම දෙයක් කරේ නැහැ අංකල්
නීල පබලු අද රාත්‍රී 9ට සිරස ටෙලිතිරයෙන්
සිම්පත හරියට ලියාපදිංචි කරගෙන තියෙන්න ඕන. සමහර වෙලාවෙම දන්නෙත් නැහනේ.
මේ සිම්පත කොයිතරම් වැදගත්ද කියලා මේ දුරකථන පාවිච්චි කරන හැම දෙනාම දන්නේ නැහැ කියලා තමයි මම කියන්නේ.
මැයි වලින් පස්සේ ලොකු ගම් වතුර තත්ත්වයක් එන්න නියමිතයි කියලා. කාලකුණ විද්‍යාඥයින් අනතුරු අංගවන පසුබිමක ඔබ කොයි විදිහටද මේ අපේ තෙත්බිම් සම්බන්ධයෙන් දකින්නේ?
කොළඹ නගරයේ තියෙන නාගරික තෙත්බිම් වලින් 21%ක් තියෙන නාගරික තෙත්බිම් වලින් වැසි ජලයෙන් 39%ක් රඳවා ගන්න බව.
දැන් විලද නගරයේ කටයුතු කරන කට්ටිය දැන් එනවා පරිපාලනය නගරයට. ඔතන මේ දන්න හැටි අපි ගත්තොත් අලවටුකොට එහෙම නැත්නම් කිඹුලවල ප්‍රදේශයේ අපිට තියෙනවා රැයට කෑම කඩ. ඉස්සර ඒක තිබ්බ කොහෙද? කොළඹ. දැන් ගොඩ දෙනෙක් මේ පැත්තට එන්න පටන් ගන්නවා. මොකද ඒගොල්ලන්ට අර පොළ පාට ගතිය. මේ තියෙන බ්‍රීස් එක කියන්නේ ඇඟට දැනෙන වෙනස අනිවාර්යෙන් දැනෙනවා.
ජාතික මෙහෙවර සතියේ දිනවල උදෑසන 11ට
You want to create your life. Create it. This is your opportunity to change your destiny. සඳහි දක්ෂිණ ද්‍රවයට ගොඩ පැසූ අතර මේ ඔවුන්ගේ චන්ද්‍ර ගවේෂණයේ පළමු මෙහෙයුමයි. Bring us this Whipslip Season 4 Saturday at 6:30 p.m. on TV1.
The People's Platform.
Good evening and welcome back. We're discussing the Personal Data Protection Act number 9 of 2022. I'm in conversation with the former chair of the drafting committee of the PDPA, Attorney at Law, Mr. Jayantha Fernando. Mr. Fernando, I think we covered a lot of ground during the first half of the discussion. In terms of businesses that need to be looking at bringing in compliance structures and frameworks to be compliant with the PDPA's provisions. Speak to us about the importance of having privacy policies that ensure transparency. How do we as business organizations collect data, store data, use data, share data? That is kind of one of the basic things that any business organization can and must do, and they need to start now because there are just a few more months till March, so the compliance processes must start at least now.
Yeah, good point, Sonali. Actually, I just want to emphasize one thing. The law, unlike some other country laws relating to privacy data protection, does not differentiate between government sector and private sector. Government sector entities, private sector entities are treated the same, right? So both governmental organizations, private sector, including our all boys or all girls clubs to any other societies that we are part of, which has a large membership list, will have the same obligation under this act. In the same way, small and medium businesses to large corporates would have the same obligation. So I know this could be a challenge, right? Considering the potential challenge to small and medium entities to large entities, and when you look at large corporates as well, some may have significant amount of personal data, right? Some may be having moderate amounts. They may not have more than 50,000 personal data sets. In some cases, like a telco or a bank, they may be having millions of personal data records. And same applies to immigration department, to our registration of persons department, to our electoral database as well. Yeah, all our electoral records are there of the entire voting population. So the law does not differentiate or distinguish between all these. The law applies to all of them. That's fundamental. Now, unlike earlier, the law specifies that in relation to entities like that, collecting, storing and sharing or doing whatever they want to do with that information. In fact, the definition of processing is something that you may like to look at. It's pretty wide. So any processing activity involving personal data should be done in accordance with the basic processing principles.
Right.
So we have in part 1 provisions governing lawful processing, purpose specification, purpose limitation, that for example every entity that collects personal data has to process it in an adequate, relevant, proportionate manner, ensure accuracy, ensure that minimum steps are taken to ensure integrity and confidentiality, and then also ensure that retention should only be for the specific period permitted by law, etc. But most importantly, it contains for the first time minimum guidelines with regard to what we call transparency, and that is through privacy notices, etc. And there was hitherto no standard in Sri Lanka governing a privacy notice. This law provides for that, and Schedule 5 contains a long list of basic information that should be included in a privacy notice.
Right.
So the minimum guidelines have been set, and then on top of that there is what we call a framework of accountability, which you don't find in the European general data protection regulations, but you find that in the APAC privacy framework, most notably in legislation like in Singapore, which provides for something called a data protection management program, a minimum checklist of compliances that should be done for in-house like housekeeping measures that can be carried out effectively to ensure compliance. And in the event of a potential violation, Sonali, as I pointed out earlier, how the law might potentially help SMEs and give comfort to them is that the regulator in the first instance is required, if there is a violation, to hold an inquiry and give an opportunity for the violating party to correct their errors and carry out their regular business, giving a directive under section 35, rectifying any anomaly or mistake they have committed. Right. It is only thereafter, for a repeat violation, that any penalties may be imposed. So Sonali, I think people should understand this. The law, true enough, is compliance based. It has penalties and sanctions, but I would qualify that by saying that it's a soft law instrument because of the evolution of privacy and data protection over a long period of time, that we need to recognize the soft law approach that is built in through that directives section, so that a regulator will not go hammering sanctions left, right and center. That was built in so that even small and medium enterprises would have the opportunity of curing their errors or mistakes or violations, and working with the regulator to build compliance measures. And hopefully over time the regulator will be able to get insights from various sectors with regard to sectoral guidelines that can be done. So that work is forthcoming, and the regulatory authority is working hard developing minimum guidelines, regulations with some of the stakeholders involved.
Just for the understanding of our viewers, you spoke of industry specific guidelines that will be gradually brought in, which are industry specific. There are several sectors that use a lot of personal data in their day-to-day businesses. How must they approach the PDPA? For example, a news division uses such a lot of data. You cover a protest, you get people's identities, their faces, their political ideologies, everything.
Yeah, so it's a very interesting point you raised, because this issue came up in relation to journalistic rights and rights of journalists to process personal data in relation to news reporting. And potentially this may be an area where the Data Protection Authority may in the future set up a thematic advisory committee.
Okay.
The law was built in such a way, knowing the various distinguishing features of various sectors.
Right.
You fleshed out news reporting, journalistic rights, which is a very important segment of personal data processing. On the other hand, you have those relating to employment. You hire a company would in an HR division would have a list of CVs in their database, right? And even before a person is hired, that person will be subject to reference checks, right? There will be a number of interesting aspects with regard to lawful processing of personal data that may have to be addressed through their internal policies, privacy notices, in line with Schedule 5 of the Act, and so on and so forth. Now, in relation to the various sectors you mentioned, the law recognizes the need for advisory committees to be set up, and I would think one area may be the areas you mentioned, because the law has got, in relation to lawful processing of personal data, processing that can be carried out in relation to public interest, and public interest aspect has been broadly formulated in such a way so as to facilitate various activities, right? And one might be able to bring news reporting and activities similar to that, but these are areas that may require perhaps guidelines from the future regulator. So I think what I'm envisaging is that knowing how the regulatory structure is being developed effectively by its chairman and the board, there is a likelihood that the various sectors that you mentioned may wish to engage the regulator.
Absolutely.
And perhaps develop the guidelines themselves alongside the regulator, so that the regulator will be advised with regard to how that specific sector can be developed. So hopefully the central bank and the banking sector will develop their guidelines, insurance regulator and their sector will develop their guidelines, right? Things like that hopefully might come in time to come.
Mr. Fernando, now in terms of minimum safeguards that need to be adopted on the one hand, and creating this privacy culture in Sri Lanka. I'll give you an example. If I go to a photocopy shop, get a photocopy of my birth certificate, and they accidentally take 2 copies, give me one, and they dispose of the other and sell it as scrap to a cuddler vendor. The cuddler vendor will be making his cuddler go to using the document that has my birth certificate, which contains my personal data. How problematic is that? Right now we have absolutely no laws governing that, except for the PDPA, which came into effect in 2022. So speak to us about this from a minimum safeguards point of view.
Yeah, so firstly, a small qualification there. The law is an act of parliament. It will come into effect on the 18th of March 2025 as of now.
Okay.
Right? So you're right. It's a very interesting example you gave of the culture shift, right? And strictly speaking, that example you gave is a classic, I would say a classic case of some processing activity done in excess of the mechanisms or the provisions permitted under the various provisions contained in this Act. The issue is how the data subject affected, the person like you whose birth certificate is being photocopied, will know whether your rights are affected or not. If the kadalakarya happens to sell you that one fine day in another street corner, and you by coincidence get hold of that same thing, then you know such a violation has happened, otherwise you will not know. So the rights of the individuals to be exercised, they have to know that their rights have been violated. That's the first thing. So in that example, it all depends when that person would get to know the violation. But strictly speaking, carrying out processing activity in excess of the lawful processing or the principles of purpose specification or other principles that are laid out in the Act are very clear, that if you give something for copying, it should only be for that purpose and for nothing else, and that entity should dispose of any additional records without selling that paper.
Right.
Now, this requires a culture shift, and we know that in any country that has brought in a comprehensive privacy law like this, it has taken years of training, capacity building, maybe education at school level, introducing this curricula not only in law schools but also in general education. It will take some time. So until that time, until we give time and space for maturity, I think it's up to all stakeholders involved in the subject to build awareness, and maybe not just programs like this. Maybe you can get other groups of end users, those who process data, to give their perspectives, share their insights, share their challenges, so that the regulator will know where to intervene and where not to intervene, and give guidance with regard to the overall implementation of this Act in future. Thank you.
All right, fantastic. Mr. Jayantha Fernando, thank you so much for such a comprehensive discussion. Thank you for watching us. We'll see you again on Friday. Good night.